We are tracking developments in the trial of 3 Tacoma police officers in the death of Manuel Ellis. Thanks for joining us. I'm Christine Pay. Ellis died while being restrained by police in March of 2020. Officers Matthew Collins, Christopher Burbank, and Timothy Rankine are all facing charges in his death. King 5 is live streaming the entire trial from opening to closing statements. We take you now to the courtroom live.
Oh, okay, another one. I put it on there, so this is
I just wanted to get my computer going. And just wanted to get my computer going and make sure we had everything ready. Good morning. And I see you've got all the deals over there on the chairs.
notepads. Oh, no. Yeah. I don't remember doing this. I told them
The chairs.
the jurors to be here no later than 8:45. And the reason is preliminary. I told them that I get in by 8, coffee will be made. They can come up here. I see them. I'll let them know.
Okay.
So if you can remember to set it on 8:45.
Did you get whatever that last thing was, that last question?
Pardon me?
You said there was a question that somebody had that you didn't remember it?
It was the lunch.
Oh, okay. That was something else. Okay. All right, I'll be right back.
Yeah, so you're. Not yet, when I go grab them. And then 8, all the way to the one. See, if it goes 16, it's 16. Right, but I don't, yeah. All please rise. Court is reconvened.
Okay, good morning, everyone. Welcome. Please be seated. Okay, my understanding there's an issue with a couple of the PowerPoints.
That's correct, Your Honor.
So I think I've got the state's PowerPoint here. So, Ms. Fricke, you have an issue with it?
Yeah, you can say that. Quite a few issues, actually, Your Honor. So I guess we'll begin.
Can you turn on your mic, please?
Begin with the court's suggestion and I guess oral order some time ago that if there were going to be PowerPoints, of course, they had to be given to the other side within a timely manner. That was done. I don't have a problem with that. Secondly, as part of the PowerPoints, if I recall correctly, you indicated that unless there's an agreement as to exhibits being part of the PowerPoint, there would be no exhibits in the PowerPoint. The state, within the last couple of days, I think Mr. Liu, I'm not 100% sure about which attorney for the state, but I believe it was Mr. Liu, had asked us if we were, would we have any objection as to an overhead photo of the scene, and we said no, so that's not a problem to the extent it's limited to that. We get this PowerPoint overnight, and it goes well beyond that. There's numerous photos of Mr. Ellis, more than one occasion, various witnesses, not all the witnesses, and Mr. Ellis again with the words, "I can't breathe," still, or something to that effect. "I still can't breathe, still can't breathe, sir," which I think it's inflammatory to say the least, but again, it's an exhibit that we didn't agree to, and we're not agreeing to it, any of these exhibits. And that includes all the photos in here of all the various witnesses, and again, not all the witnesses. And secondly, after you get through the exhibits that they're intending to have displayed to the jury right here in opening statements, then they have a discussion of the law. And this is not argument. This is opening statement. They have instructions on use of force and various other instructions that the court presumably will be giving sometime at the end of this case. They have a definition of the caretaking function under RCW 3628A445. I mean, all that's argument and should not be allowed during the course of the opening statement. And so we're asking the court to keep out the exhibits, specifically the photographs, as well as the argument that's contained in the various instructions that they have as part of their PowerPoint, including, I don't know if it's there. Yes, okay. But that's the basis of our objection, Your Honor. And I don't know if other defense counsel have similar objections or more broader objections or what, but that's the basis of our objection.
Well, specifically, what page numbers?
Well, I don't have page numbers, but if we can go, so page 2, I guess I'll just flip. They do have numbers? Okay.
Yes.
Oh, page 2, okay, I take that back. Page 2,
That's a photograph.
that's a photograph.
Okay.
Page 7, which is 3 photographs of our clients. Page 9, page 10,
Hold on a second. Okay.
11, 12, 13, 14,
Did you say 15?
14,
14? Okay.
and then, 15, 16 are argument. 17, which is a statute. 18, which is argument. 19, the photographs, and to be consistent. 21, which is exhibit. 22, 23, 24, which is, I would suggest, inflammatory. There's nothing putting a photograph together with at least an allegation of Mr. Ellis making that statement at a time. I cannot read the following page. I don't know if it was deliberately blank or what. And then the other photographs that follow, those are, okay, that's fine. Okay, so that's the end of it, Your Honor.
The rest of this is Officer Rankine's
It might be, yeah, that got them together.
PowerPoint. Okay. Other defendants have a remark?
Officer Collins joins in the objection.
Can you turn on your mic, please?
Officer Collins joins in the objection. In addition to the basic.
Wait, hold on. Ma'am, you're having trouble hearing? I guess you just cupped your hand to your ear, so I expect that much. You want the headset? You want a headset? You need 2 of them? Sure, we'll get you some.
What's that?
Okay, go ahead, Mr. Officer.
Thank you, Your Honor. Your Honor, Officer Collins joins in the objection for the reasons stated by Mr. Fricke. In addition, I'd ask the court to look at pages 15 and 16. The state has put shadowy figures in a hobble restraint with 3 shadow officers around them. That's, I think, inflammatory, not accurate, and argument. And as Mr. Fricke indicated on the second to last picture of Mr. Ellis, still can't breathe, sir, is akin to Glassman. And the court has found that that's error. Imposing words over the photographs that are not accurate is error, and so that certainly should be removed. And I agree that all the other slides should either be altered or removed. Thank you, Judge.
Mr. Conrad, do you have a comment?
Your Honor, I join in the objection of the rest of the defense. And excuse me, Your Honor, I have a bit of a sore throat today. So, with regard to the statements of law that the state provided within here, I mean, not only do I believe that it's argument and opening and it's incorporating what they propose are going to be certain. I mean, they didn't propose these as jury instructions, actually. The use of force slide comes from the definition of necessary under defenses to a lawful use of force. Again, I'm not even sure that we offered that within our instructions. So for the state to suggest that we would be offering that or to make argument as to the use of force, it's just not applicable and shouldn't be done in opening statements. I share in counsel's concern about these, the inflammatory nature of the timeline. I mean, just having a timeline is one thing, but having these, these pictures of law enforcement officers standing there with authority, with, old caps on, and an individual that's in hobbles pictured there is, again, it just goes beyond what's necessary. And the last thing I'll point out is the caretaking function that the state cites under RCW 3628A 445. Again, that's improper argument and opening, and that statute doesn't even apply here. I've done an analysis on that, and I'm happy to provide the court further briefing on that. But under that statute, if you look at it, subsection 2 says that within 1 year of enacting the statute, the Washington State Criminal Justice Training Commission shall develop guidelines for implementing the duty to render aid and adopted in this section. Well, what ended up happening then within that year, and if the court remembers, this is a period of time when I-940 got passed and there was a lot of change that was happening within the legislature with regard to use of force And so what they did was, in December 7th of 2019, they enacted WAC 139.11.020, subsection 1A T2, and they said that any officer that was going through BLEA or the academy at that point, excuse me, needed to be trained on this new policy. Obviously, these officers, there's my voice back. Obviously, these officers had already gone through the academy at that point. So the second half of that said, if you've already gone through the academy, you have 3 years under which you should be trained in order to promulgate this new duty. That hadn't happened at this point. So that statute's not even applicable here. I don't know if the state's aware of that and they're just trying to mislead the jury in that regard, but this statute's not applicable. It required additional training to be implemented and development of these guidelines. And until the state shows that they had the training, which they didn't at that point, in order to render that new policy and that duty, it's just inapplicable. And it doesn't apply within the opening statement at all. So, I share in the concerns as well with you have this picture of the spit hood and the warning label again in there. The state's failed to show that this warning label had ever been shown to any of these officers, that they had ever asked for the spit hood, been trained on the spit hood, knew what the warning label said. And so, again, I think that that's evidence that's not been admitted, and until it is, the court should not allow it within opening. And then my last concern, again, is this statement, or this picture of Mr. Ellis with the still can't breathe, sir. And those are that's in dispute whether I think some of those statements are actually been made. I think I made that clear in our motions in limine, but to have that with the depiction of Mr. Ellis behind it, I think is particularly inflammatory.
Okay. State's response.
Yes. Can you turn on your mic, please?
Okay. With respect to the picture of Mr. Ellis, we have a single picture of Mr. Ellis. From the state's perspective,
It looks like it's in here twice.
It is in here twice, but it's only one photo. So I would just say, first of all, it's only one photo. With respect to the last photo, these words are a direct quote from, and that's why they're in quotes and they're listed the way that they are, because that's the evidence that the state will present, is that these were the statements that were made. So that's my response with respect to those. The Exhibit 30, the RCW caretaking function, that is simply, these are not arguments about it. The officers have a caretaking function. This is the statute that applies with respect to their obligation once somebody's in custody to take care of somebody.
Well, who's going to testify about that?
We'll have testimony about that from witnesses who trained at BLEA, as well as Chief Rankine.
They're going to say this is the policy of the state of Washington, this is the training.
They're going to say that they're trained on that, yes, correct.
What about these officers?
The use of force, with respect to these officers, yes,
Yeah.
these officers were trained on that as well, on their caretaking function when somebody's in custody.
Well, this seems to anticipate an instruction from the court.
That's not what it was intended to do.
Why have the citation to the code, to RCW?
Only because explaining to the jury that they have an obligation to take custody or take care of somebody once they're in custody. And that's simply the fact of it. If you want us to take off the RCW, we can. That's fine. We weren't anticipating the instruction nor intending to argue about what the law is, but simply to make the point that they have a caretaking function once they have somebody in custody.
Well, I never understood the state's position here to be that these defendants failed to obtain medical care at the earliest safe opportunity as part of the claim of the state here.
The state's case is in part that the officers had an obligation, once they had Mr. Ellis secured, to attend to his medical needs.
Yeah.
Clearly stated repeatedly that he couldn't breathe, and that they failed in their caretaking duty to address his medical issue.
Well, as I understand this, and maybe I'm wrong about this because I don't know the facts nearly as well as all of you, other officers arrived before the situation with Mr. Ellis was resolved, if you will, and they're the ones that called for care, right?
No, it's actually not accurate. Other officers arrived. Sergeant Lim was radioing with dispatch. Dispatch asked whether fire should come, and Sergeant Lim said, yeah, you might as well have them come and check him out.
Right.
That was the communication.
Another officer said that.
Correct.
Okay, keep going.
With respect to the use of force slide number 14, that's actually a statement, I believe, from the Tacoma Police Department manual. Let me just confirm that. Yeah, that's not an instruction on the law or anything else. That's a statement in the Tacoma Police.
Seems like an instruction on the law. That's what I would think it is.
Well, and in opening statement, we can make it clear that it's not, that it's just the statement of the Tacoma Police Department that this is what the direction is to these officers with respect to when they can use force.
So you're going to say that this is what you expect the testimony to say about this?
Correct.
Because otherwise it just simply looks like the law.
Correct. Well, these are not intended to be, obviously they are accompanied by the comments of counsel.
Right. But you know, there have been cases where PowerPoints have actually stated things correctly, but they've used red lettering, or they repeated things, or they've used larger type of certain kinds of things that were regarded to be inflammatory, and those things have been struck. So it isn't just that you're right or not, it's also that it not be inflammatory. What about all the little pictures on 15?
With respect to those, Your Honor, this is simply, and again, will be accompanied by comments of counsel. This is just a recitation of the facts.
Right,
And
right,
this
but I'm thinking about all these little pictograms that are on here.
Right, and that's just to depict the condition that Mr. Ellis was in and which officers were present when those statements were made.
Right, but aren't the pictograms kind of inflammatory?
I think that they're an accurate representation of what the facts are going to be.
Wasn't there some representation of the fact that Mr. Ellis was at least at sometimes on his side, not on his back, not on his stomach?
He was briefly on his side, according to Officer Rankine, and then rolled immediately back to his stomach and placed his weight back on his back.
Well,
That's what Officer Rankine's statement is.
other officers say something different, though, right?
There's a wide variety of things that other officers say.
But these pictograms only have him on his stomach,
Correct,
not on his side.
correct.
You think that's inflammatory or misleading?
We don't think it's misleading based on the totality of the evidence, but if the court wants us to take those off, we will.
Oh, well, okay, keep going. What else have you got?
With respect to the pictures, the pictures are just of witnesses, and the photographs on 9, 10, 11, 12. These are the 4 witnesses that were eyewitnesses to the initial incident.
Why do you have them listed twice, photographed twice?
I think it's just that they're summarized. They're each shown individually. Counsel intends to talk about each one, and then the slide 13 would just be kind of a summary with respect to what their testimony is going to be, which is why they're all 4 on one slide at the end. Well, we could do it differently if the court prefers and pull each one up on each slide and then, at one at a time, and then have them all 4 at the end if the court prefers us to do that. But that's what the slides are for.
All right, what else?
With respect to slide 7, that's just photographs of the defendants taken the night of this incident by the Pierce County Sheriff's Office.
Because as Mr. Fricke mentioned, and as I had said before, I wasn't going to allow anybody to show exhibits to the jurors until they've been admitted. Wouldn't this be an exhibit?
And which number are you looking at?
Number 7.
Oh, I'm sorry, number 7. I suppose, yes, if the court doesn't want us to put photos of the defendant on that night, we won't.
All right. What else did you want to say?
And with respect to slide number 21, those warnings, again, it's illustrative of what the warnings were. They were individually packaged in each one of the split hoods that were handed out to the officers. And I'm just trying to see if we're missing any others.
What about the picture?
The picture, again, is just illustrative from the website with of Safari Land.
But that would also be an exhibit, right?
It may be.
Okay. Any further comment?
I'm not sure if the court has any other. So with respect to the overhead pictures, these overhead pictures are simply marking
I don't think they object to that.
locations.
They don't object to the aerial photographs.
All right, I thought you said they went further than that, so I'm just making sure. And I don't think I have any other comments unless the court has questions.
No, but I think most of this is problematic. Let's put it that way. There's one slide here which is the picture after Mr. Ellis and the quotation underneath his name, but it seems to be just blank. Is that just here's mine. I mean, it's just
It's
blank.
just a final blank slide at the end of the PowerPoint.
So there's nothing there.
No, there's nothing there.
Okay, great. I think most of this is problematic. You can have your timeline, and you can have the aerial photographs. With respect, you should take out the pictures of the officers. That's an exhibit. The pictures of the witnesses. I mean, you can list their names, but certainly, but the pictures should go. The use of force slide should go. You can talk about what you anticipate the testimony is going to be, rather than telling them what you think the law is as to all of this. As for the timeline that goes, it starts at page 15. All the little pictograms of the officers and I imagine this is Mr. Ellis with the person that's tied up, these sort of dark shadowy sort of figures here, those should all go out. The pictograms can go out. The timeline for him indicating he couldn't breathe, that's fine. Might as well take the pictogram of the fire truck or aid truck or wherever that is out too. 17, caretaking function, that goes. And of course 18's the same kind of thing with the pictogram. And then I think that's, let me see, then is this Officer's Rankine account, that's part of this too, right? Take the picture out. The rest of it's fine. Number 20, take the pictogram out. The rest of the array of names is fine. 21, take the pictures out. 22, take the pictograms out. 23 are photos, and that should go out. 24, a picture of Mr. Ellis with the quote underneath should go out. And then we have the blank page.
We leave the photo of Mr. Ellis at the end, but without the can't breathe.
No, it's an exhibit,
So the first picture of Mr. Ellis you're also not going to allow?
right? Now, as I understand it, there's some concern by the state about Officer Rankine.
Correct, Your Honor.
He's got lots of exhibits too.
Yes, and he has lots of photos. So we would object to the photographs of, on the first page, the second page, and I'm not sure where that location is, the third page, with him and his wife and dogs.
Right.
The picture of Messiah Ford, we would also object to. The next one, radio traffic, this is from an exhibit. So I don't believe that that's, given the court's ruling, that should be in. And then
Yeah, go ahead.
with respect to the one on Dr. Clark, two issues with that, or several issues with that. First of all, both are quotations from exhibits. So those are direct quotes from an exhibit. With respect to the second quote, this is hearsay. It may be impeachment. I think I don't agree that it's even a proper opinion, that the court has indicated that if a question were asked of this nature as to his opinion about whether or not the state could prove its case beyond a reasonable doubt, that the court wouldn't, I believe the court said that you wouldn't find that you would sustain an objection to that. But even if it's not an improper opinion or it potentially comes in, at best it's impeachment. And since Dr. Clark hasn't testified, we don't know if he'd be impeached by it, but certainly the memo itself wouldn't come in as an exhibit. So I think it's also, his offering an opinion in this nature and this quotation here is also essentially invades the province of the jury by telling them that they shouldn't find guilt because of his personal opinion. And I would cite the court to State versus McPherson, 111 Washington App 747, that addresses that issue. And then on the final one, that is obviously a jury instruction.
Right. So, Ms. Bremner or Mr. Conrad?
Mr. Conrad, Your Honor. If you can speak, voice is back.
Let's hope we can do it.
Well, Judge, given your ruling most recently with the state's exhibits, I guess the only difference I see between some of these pictures is they're illustrative in nature, and we won't move to admit them.
That doesn't make it any better.
Okay. Well, I figure I'm not going to hit my head against the wall, and I think the court's been consistent in its rulings throughout this case so far. So
Well, I've tried to be.
yeah, and so I understand the court's position on that. So sounds like the court's going to want us to remove all photos of our client as well as Ford. Is that correct? Do we have any photos? I'm not sure if the state was.
No need. You can talk about Officer Ford, but no photograph.
Okay, understood. And then the radio traffic, I mean, it's very different, obviously, than the state's timeline. It's merely a timeline. Rather than me typing out these same timestamps and what the transmission is, we elected to use what the actual, what it shows. So if the court wants us to just type that out, we could do that. Same thing.
Well, it's an excerpt from something that may or may not be an exhibit. I don't have a problem with this.
Okay. I didn't see any issue with the slide on Rankine. No photo.
That's fine.
And then the Pierce County Medical Examiner, the quotations in there. The state also has quotations about breathe, things of that nature. Obviously, we're not using the actual autopsy report as an exhibit, but we're certainly entitled to pull out information that's contained within that we anticipate that the jury will be hearing. And so that's what we've done here. So I thought this was in line with the court's ruling because we're not using an exhibit. We're using quotations just like the state is. And that's what we anticipate the evidence
Well,
to show.
I've got no problem with you got three dots here. I got no problem with the first two.
Okay.
The third one may or may not be impeachment. We don't know what Dr. Clark's going to say. But isn't this a witness offering an opinion about guilt, if you will, one way or the other, in the sense of providing an opinion about the legal standard being met or not?
I don't think so. I think that it's different because, number one, it's an expert. So we've seen, obviously, case law, and the rule says that just because it touches on similar issues that the jury needs to decide doesn't mean that it's excluded. And
Well,
here,
that's true, but they don't usually say something like, so in my opinion, the defendants are guilty, or in my opinion, the defendants are not guilty. They don't say that.
no, and I don't think
And,
that.
and that's approaching, this statement is approaching that kind of thing.
I see a distinction, and the distinction to me is we have medical experts who are going to opine to a certain degree of medical certainty as to what caused Mr. Ellis's death, right? Whether it be the positioning of him, restraint-related issues, positional asphyxia, whether it's a homicide, properly categorized as a homicide or not. And here, what Dr. Clark is saying is, I can say to a certain degree, to a degree of medical certainty, that I believe this is a positional asphyxia case, but I can't say beyond that preponderance standard, if you will, that that's what occurred here. And so, if you're asking me to go beyond that in a criminal case, I wouldn't be able to meet that standard. So I think that's different than commenting on the guilt or innocence of a defendant, because he's talking about cause of death. And so I think there's a distinction there.
Okay. And then the last one about the instructions, that should go out.
Okay, understood.
So with respect to that slide about the medical examiner's testimony, as I say, the first 2 points are in. The last point,
Oh, I'm sorry, I apparently have a different version. I have 2 points on it.
looks like this.
We just got something new apparently, and what I handed to the court.
I think we updated it this morning.
Oh, I'm sorry. Okay.
Sorry, Ms. Eeks.
I didn't see it. I apologize. I was reading one with only 2 points on it.
Okay. So
You're saying the first 2 points are okay, but the third?
third I've got a problem with. Third goes out. It may come in during the trial, I don't know, but
Okay.
at this point in
Understood.
time, I don't think so. So, you guys understand the redactions that need to be made here?
I believe so, Your Honor.
How quickly can you make them? The
I
jury's
think we can
waiting.
make ours pretty quickly and then we'll print new copies for the defense and make sure everybody's aligned before we start.
Can I say out loud right now that I long for the days when PowerPoint didn't exist?
That one, Your Honor.
I think you previously said that, Judge, and the proof,
Some
the
of us
proof is in
agree.
the pudding.
Okay, so in
Taking a momentary break.
well, I was looking at, would remind you of one more thing. When the jury comes out, I'm going to give them the note-taking instruction, and then we're going to proceed to opening statements immediately thereafter. And is Ms. Eeks, are you or Mr. Liu going to do the opening? Mr. Liu? Okay, great. Now, you said you needed a break?
If we're having one, utilize it.
You're at liberty to leave anytime you want. I'm hoping this isn't going to take very long, because if it's going to take very long, I'll just say discard it and go ahead. How much time do you guys think it's going to be? I'll tell you what. No PowerPoint. You guys can use them as your guide for your own opening statements and read your own deal, but don't show it to the jury.
I think we're done with ours.
You're done, then why'd you need 15 minutes?
Well, I let them look at it. I thought the court wanted me to let the defense look at it. But,
Well, we do need to know whether or not you've made these redactions correctly, yes.
right, and Corey's just finishing them up right now, but I can show you guys a look at the computer. We're gonna print them, but if the court wants to have a look at it.
Your Honor, we're fine with no PowerPoint. Thank you.
Let's proceed. No PowerPoint. Mrs. Winnie, let's have the jury.
Your Honor, does court have an easel that, I mean, the state brought in an easel for a different exhibit that everybody's approved. Does court have an easel that we can?
You got me. This is my courtroom. I don't know. There is an easel somewhere around here.
That's ours, that we brought in?
Your Honor, can I raise a quick issue? I've got an audience member that, when I look back at the audience,
I can't hear you.
I've got an audience member that when I turn my head and look at the audience is just glaring at me and shaking her head. I guess I would just ask that the people watching be reminded to not exhibit any displays of really any emotion while we're up here in court.
Well, that's certainly appropriate. This is not the Jerry Springer show. There's no cheering as people testify. There shouldn't be any audible or visual expressions of agreement or disagreement with anything that anybody is testifying about. We need to make this as neutral a venue as possible.
Do you mind if I crowd you just a tiny bit? Just temporarily. Okay.
Okay, I'll bite. What's on the other easel? Is that a photograph of Mr. Ellis? No? What is it?
It's an overhead.
An aerial view of the scene? So you can use it if you want.
Pardon?
You have no objection I'm using that? Okay. right, good morning, everyone. Welcome back. Please be seated. Okay. Ladies and gentlemen, on your chairs this morning, you should have found a clipboard with a manila envelope, and I want you to open the envelopes and make sure that you have inside a notepad to write on and a pen or something that's useful that you can write with. And if somebody does not have that, let me know. Looks like we're good. No pen? Okay. I'll get you one. You got a pen? Okay, great. All right, so members of the jury, as I indicated yesterday, during the course of the trial, I'm going to allow you to take notes of the testimony and of the lawyer's opening statements and closing arguments if you wish. I'm not urging you to take notes. I'm not instructing you to take notes. I'm merely making it possible by providing you with a notepad and pens and so on to write with. I do caution you to not seek to take detailed or word-for-word notes, as that would probably interfere with your opportunity to observe the demeanor of witnesses and other events of the trial. Each notebook is your own, not to be disclosed to or discussed with any other juror until during your final deliberations, and then only if you so choose. At each recess during the trial, you should leave your notebook on the seat of the chair, either inside of the envelope or face down, so that a casual passerby cannot see the contents of your notebook. You'll not be permitted to take the notebook out of the court or the jury room. Mrs. Winnie will check each evening to make sure that all the notebooks are there. So when we have a recess, for instance, you leave the notebooks in here. When we leave, you're only going to take the notebooks back to the jury deliberation room once we get to final deliberations. Okay. Now, after you've reached a verdict, Mrs. Winnie will collect your notebooks, remove your notes, and then destroy them. Neither she nor I nor anyone else will ever be allowed to read your notes. And in addition to all this, two more cautions. First, I'm also taking notes on my laptop computer. You've seen me with a little array of monitors here. You shouldn't draw any conclusions from the manner in which I take my notes, because I am taking my notes for an entirely different purpose than you are taking your notes. And second, do not assume that any particular note you may make is necessarily accurate, any more than your memory may be. And so that at all times, please keep your minds open to the notes or memories of your fellow jurors. Okay. Ladies and gentlemen, will you please now give your attention to the opening statement of Mr. Kent Liu on behalf of the plaintiff in the state of Washington. Mr. Liu.
Thank you, Your Honor. May it please the court, counsel, members of the jury. Can't breathe, sir. Can't breathe. Breathe, sir. I can't breathe. Can't breathe, sir. Can't breathe. Still can't breathe. Still can't breathe, sir. Those were the last known words of Manuel Ellis, a 33-year-old man from Tacoma who died on March 3rd, 2020. He said those words over the course of 2 minutes while in police custody. And before he said those words, he had been tackled to the ground. He had been punched in the head over and over and over again. He had been choked into unconsciousness, and he was tased 3 times with 2 taser probes still stuck in his chest. And as he said those words, he was on the ground, on his stomach, pressed to the ground by an officer on his back. Despite enduring all of that, the only thing he said was, "I can't breathe, sir." We know that all these 3 defendants heard him say it, but they chose to do nothing. They didn't help him. Instead, Mr. Ellis was told to shut the fuck up. They could have brought him up, make sure he could breathe, but they didn't. Instead, they kept him down on the ground, pressed him against the pavement with an officer on his back. Defendant Timothy Rankine, a 200-pound man, got on top of Mr. Ellis and kneeled on him for about 6 minutes after he had last said, "I can't breathe, sir." When the first paramedics arrived at the scene, it was now about 9 minutes after Mr. Ellis had last said, "I can't breathe, sir." The paramedic found Mr. Ellis unresponsive. His eyes were fixed in place. His pupils were dilated. In the paramedic's presence, Mr. Ellis stopped breathing altogether. His body, starved of oxygen, shut down. His heart stopped beating. Mr. Ellis died right there in the street. He didn't even make it to the hospital. He died right there in the street because, as he told these 3 defendants repeatedly, he could not breathe. We are here today because none of this should have happened. Mr. Ellis should not have died that night. He should not have been held down to the pavement with an officer on his back. And the evidence will show that Mr. Ellis did nothing wrong. And he should not have been punched. He should not have been choked. He should not have been tased. He should not have been restrained. And he should not have been arrested. He should have died that night. Now, how did this happen? I'm going to take you to the evening of March 3rd, 2020. And it was a normal evening for Mr. Ellis. He had gone to church earlier that evening. And after returning home from church, he had dinner at his house with his housemates. And after dinner, he went for a walk to go get some snacks. And people who know Mr. Ellis will tell you that he loves his snacks. And this is what he does regularly. He will take on a walk, go to the 7-Eleven, and buy some snacks. So he goes to a nearby 7-Eleven, and he purchases a box of donuts and a gallon of water. And this is not the actual evidence, but this is what he purchased at the store.
Points on what can be used in opening statement.
It's not.
Thank you.
This is demonstrative, Your Honor. This is not evidence.
Well, sustained. Put those away.
Mr. Ellis goes to 7-Eleven, makes his purchase. Then he starts his walk home. He walks eastbound on 96th Street South, and then he gets to 96 and Ainsworth. You'll hear from 3 eyewitnesses at the intersection, and these 3 eyewitnesses will tell you what they saw. They will tell you that they saw Mr. Ellis walking on the sidewalk, just walking on the sidewalk. They'll tell you that there was a patrol car stopped at the intersection. And we know inside the patrol car was Defendant Collins and Burbank. We know that Defendant Collins was driving the car, patrol car, and Officer Burbank was sitting in the passenger seat. The eyewitnesses will tell you that they see Mr. Ellis walking on the sidewalk, and it appears someone in the patrol car called him over, got his attention. So they see Mr. Ellis walk over to the passenger side of the patrol car. They see a brief conversation take place. Then they see Mr. Ellis turn his back to the patrol car and start stepping away. Then they see the passenger door suddenly swing open and Mr. Ellis's door check knocked down by the door by Officer Burbank. Then the witnesses see both officers jump out and start attacking Mr. Ellis. He's pushed to the ground and he's punched over and over and over again. These 3 witnesses are shocked at what they're seeing. And 2 of them took out their phones and started recording. One of those witnesses is Sarah McDowell. She was in the car directly behind the patrol car at the intersection. And she got out of her car and started yelling at the officers. She yelled, "Stop hitting him, just arrest him." Behind her was her ex-boyfriend, Keon Lowry, and he had their daughters, 2 daughters in the back seat. He was also shocked at what he was seeing, and he leans out and yells, "Y'all in the wrong right now." The 3rd witness at the intersection is Seth Cowden. He was on Ainsworth. Mr. Callen was here, and he had a different view, but he was also shocked at what he saw, what he was seeing, and he started recording with his cell phone. You will see Mr. Callen's cell phone video, and you will see Ms. McDowell's cell phone video. And in those videos, you'll see Officer Burbank tackling Mr. Ellis and pushing him to the ground. You will see Officer Collins then get on top of Mr. Ellis, and you'll see him strike down repeatedly on Mr. Ellis's face and head. And you'll hear on the audios, on the videos, Mr. Ellis screaming in pain with each strike. And you will see Officer Collins get behind Mr. Ellis, and you'll see him wrap his arm around his neck in a chokehold. And in the video, you will see Mr. Ellis go limp and go unconscious. And you will also see Officer Burbank pull out his taser as Officer Collins had Mr. Ellis by the neck. And you'll see Officer Burbank fire a round of taser into Mr. Ellis's chest, sending 50,000 volts of electricity into his chest, not once, not twice, but 3 times. Now, you'll also hear about a fourth eyewitness, Ayanna White. She lives in this house in the corner. She will tell you that she heard the commotion outside, looked out her bedroom window, and sees an officer attacking Mr. Ellis. All 4 of these eyewitnesses didn't know each other, besides, of course, Keon and Sarah. But none of these 4 witnesses knew Mr. Ellis or the officers or each other. And they will all tell you the same thing. Throughout all that Mr. Ellis had endured, throughout all what the officers were doing to him, he never fought back. He never struck back at the officers. And they would tell you that it was the officers that was attacking Mr. Ellis. And despite all that Mr. Ellis had to endure, he said one thing: "Can't breathe, sir. Sir, I can't breathe." The witnesses that left the scene drove off. And as they drove away, they captured the last moments of Mr. Ellis's life. The videos will show that Collins and Burbank were on top of Mr. Ellis after having tased him twice already. He was under their control as they were driving away. Shortly after they drove off, defendant Timothy Rankine arrives on the scene, partner Officer Ford. Timothy Rankine and Officer Ford jumps out of the car and runs over. And defendant Rankine then helps Officer Collins hold Mr. Ellis to the ground. In the meantime, Officer Burbank retrieves a strap, and you'll see this during trial. It's called a hobble cord, but it's like a cargo strap. And Officer Burbank uses that strap to tie Mr. Ellis's ankles together and connect it to his handcuffs. So Mr. Ellis is essentially hogtied. So, hogtied in that position, defendant Timothy Rankine decided to get on top of Mr. Ellis. And he sits on top of Mr. Ellis for at least 6 minutes after Mr. Ellis has said, "I can't breathe, sir." And defendant Timothy Rankine will admit to investigators a few days after this incident that he heard Mr. Ellis say, "I can't breathe." But he chose to do nothing. Instead, he put him in the prone position on his stomach and got on top of him. And he will admit that he stayed on top of Mr. Ellis until fire arrived, which is 10 minutes after Mr. Ellis last said, "I can't breathe, sir." The evidence will show that the defendants chose not to help Mr. Ellis, despite all of their training. Despite all the training, they didn't move Mr. Ellis off his stomach. They didn't remove his restraints. They didn't remove the spit hood. And they didn't set him up to make sure he was breathing. And contrary to all their training, they kept him prone on the pavement with defendant Rankine on his back. And so they did nothing to help Mr. Ellis. And Mr. Ellis slowly died, slowly asphyxiated. He couldn't get the oxygen he needed, so his body and his heart shut down. Paramedics arrived and they tried to do everything they could, but it was too late at that point. They did everything they could to try to save Mr. Ellis, but it was too late. Mr. Ellis was pronounced dead right there in the street at 96 and Ainsworth, surrounded by the defendants that had done this to him. Now, before I talk more about the evidence and about the encounter, I do want to spend a moment to talk about the three defendants in this case. You'll learn that, and I've mentioned already, that Officer Burbank and Collins were partners that night. Officer Rankine was partners with another officer, Officer Ford. And those two were in a patrol car together. Collins and Burbank were in the patrol car together at the intersection. Matthew Collins joined the Tacoma Police Department in 2015. He's an experienced officer. He is an officer, but he also trains other officers on how to detain, control, and arrest a suspect. And you also hear that he is a proficient grappler. He was captain of the grappling team in the Army. Officer Christopher Burbank is also an experienced officer. He started in 2011 in North Carolina working for the Winston-Salem Police Department. He then joined the Tacoma Police Department in 2015. Officer Timothy Rankine joined the Tacoma Police Department in 2018 after having completed his training at the Washington State Criminal Justice Training Center, as well as Officer Collins. As the judge has informed you, this is the opening statements. It is our opportunity to tell you what the state will present, give you a summary of the evidence the state will present in this case. But before I get into more details about the evidence, I do want to talk about the charges in this case. The state of Washington brought criminal charges against all three of these defendants for the death of Manuel Ellis. The state has charged defendant Collins and Burbank with second-degree felony murder. Now, at the end of this case, the judge will instruct you further about the law that applies to this charge. But it's important to note to you that the defendants are not charged with intentional murder. This is a different type of murder. And the judge will instruct you about the law at the end of the case. And what I expect the judge to instruct you is that the state does not have to prove that.
The instructions of the law in an opening statement.
Sustained.
Thank you.
What you will learn is that the instruction, you also learn that these two defendants are charged alternatively with manslaughter in the first degree. And you'll learn that Officer Timothy Rankine is also charged with manslaughter in the first degree. And again, the judge will provide instructions to you at the end of the case. What do I anticipate the instructions will be, and what you need to know for now, is what that state needs to establish that.
I'm sorry, objection, Your Honor, same basis.
I'm not sure. Mr. Liu, continue what you were saying. I'm not sure that it was.
Sorry, Your Honor. You'll learn from the judge, when you're given the instructions, that what the state has to establish is that the defendants acted in a criminally reckless manner that caused Mr. Ellis' death. Now, I want to talk about the evidence that the state will present to you during this case. And I'm going to start by telling you about Manny Ellis and the last day of his life. His friends and family call him Manny. You will learn that he loved music and he loved playing the drums. You'll learn that he has a mom, Marcia, sister, Monet, brother, Matthew. He has nieces and nephews and other family members that loved him. You also learn that he had a daughter named Alexis, who was 3 years old at the time of his death, whom he loved very much. You will also learn that the church and his faith meant a lot to him. And you also learn about some of the struggles he had. In fact, going to church that night is how he started the evening. He went to church with Cedric Armstrong and Kimberly Mays. This is the couple that ran the clean and sober home that he was living in at the time of his death. And you'll learn that a clean and sober home is for people like Mr. Ellis who have struggled with addiction. Mr. Ellis, you will learn, has struggled with addiction through most of his adult life, and in particular to methamphetamine. He worked hard on it, but he relapsed at times, but it has caused a lot of pain in his life. And it culminated in a scary incident in 2019 where he was in a meth-induced psychosis, was naked on the street, and was confronted by officers, and he was arrested. That was a scary incident for him, and it was a turning point for him. He started to change his life, started to engage in treatment and attending church on a regular basis. With the support of his family, Mr. Ellis went into the clean and sober home with Kimberly and Cedric. And he was still working on his recovery, and it's difficult, as many of you can imagine, with Mr. Ellis having gone through that for most of his adult life. And he relapses on occasion, and you'll hear he relapsed on March 3rd. But he was doing all the things that he could to try to change his life around. And he was trying to balance living a normal life with his addiction. Now, you will hear about the events of March 3rd and what Mr. Ellis was doing that night. And this is important because you will learn that he was having a normal evening, and everyone that interacted with him will tell you that he was his normal, happy self. He started that evening going to church at 7 p.m. with Cedric and Kim. And they were doing a revival, which is a several-day stretch of worship and music. And in fact, it was Mr. Ellis that suggested that they go that night. Cedric and Kim will tell you that they were tired and wanted to stay home, but Mr. Ellis was excited. He wanted to go. And during church, he played the drums. They returned home at about 9 p.m., and during the drive home, he was telling Cedric and Kim how excited he was, how he wanted his mom and his sister to come to church. When they got home, Mr. Ellis placed a phone call with Tiana Matt. This is Alexis' mom. Tiana is Mr. Ellis's former girlfriend, and they have the child in common, and she was 3 years old at the time. And you'll hear from Tiana Matt. She will tell you that Mr. Ellis calls Alexis every night to say goodnight to her, to wish her goodnight, and to tell her he loves her. And you'll hear from Miss Matt that Mr. Ellis was his normal, happy self that night. And you'll learn that after that, he had a call with his friend, Brandon McClanahan. It was a short conversation, but Brandon will also tell you that he spoke to Mr. Ellis, and he was his normal self, nothing unusual. And then he had a FaceTime call with his mom, Marcia. And you will hear about that call, and Marcia will tell you that he was happy, he was excited about church. He talked to her about what he did that night. And he was talking about his plans, about how he wanted to get his life together, and he wanted to start a business. Mr. Ellis' sister, Monet, was in the house with Marcia, and she overheard that conversation, and she could hear Marcia and Mr. Ellis laughing during the call. It was a good call. That would be the last time Marcia would speak to her son, and that would be the last time Monet would hear from her brother. A little bit after he spoke to Marcia, Mr. Ellis went out for his walk to the 7-Eleven to get his snacks. You will learn that Mr. Ellis took this particular route to the 7-Eleven. He goes from the residence, from the Clean and Sober home, goes eastbound, then goes up north on Ainsworth, then goes westbound on 96 to get to the 7-Eleven, because he wanted to avoid a certain part of that area. So he takes this roundabout way to get there. And you'll hear more evidence about that during trial. And you'll hear from the clerk at the 7-Eleven, and she will tell you that she recognized him as a regular, and there was nothing out of the ordinary that night with Mr. Ellis. He came in and made his purchases. And Mr. Ellis then started walking back home. He was walking eastbound on 96th Street when he came upon 96 and Ainsworth. That night, as I mentioned, Officer Burbank and Collins were on patrol together when he encountered Mr. Ellis walking on the sidewalk. Just before this, about 2 to 3 minutes before this, those two officers had been at a prior traffic stop about a mile away for a headlights violation. And Officer Ford and Rankine backed them up on that call. And from their location, the previous stop on 96, it takes about 2 minutes to get to this intersection. So they would have arrived to clear that call about 11:19. They would have arrived at the intersection about 11:21. You also learned that from walking from the 7-Eleven to this intersection would have taken about 10 minutes. And we know that Mr. Ellis made a purchase at 11:11. So he would have reached the intersection about 11:21. So they would have gotten there about the same time. Now, as I indicated, this is an overhead view of the intersection where the event took place. What you will learn is that Officer Collins and Officer Burbank were stopped right here at the stop line. And you'll learn that the 3 civilian witnesses arrived shortly thereafter. Sarah McDowell was in her car directly behind the officers, and Keon Lowry, with their 2 kids in the back seat, was stopped behind her. And you will see and you will hear that Seth Cowden, he's a pizza delivery driver. He was here. Seth Cowden was delivering pizzas that night, and he had just completed a delivery and was on his way back to the store when he saw what occurred. You'll also hear from the 4th witness I mentioned earlier, Ayanna White. She lives in this house right here. And she looked out her bedroom window. During the trial, you will hear from each of the civilian witnesses, Sarah, Keon, Seth, and Ayanna. And what all 4 of these witnesses will tell you is that Mr. Ellis was not aggressive, was not violent, never attacked the officers. In fact, it was the officers that was attacking Mr. Ellis. They all saw the same thing. And again, none of these witnesses, besides Sarah and Keon, knew each other. And what these 3 witnesses will tell you is that Manny Ellis was walking on the sidewalk here when he was then called over, or someone in the patrol car got his attention, and he walked over to the passenger side of the patrol car. And what they will tell you is that a brief conversation occurred. Mr. Ellis then started stepping away, and the passenger door swung open, and that was Officer Burbank, knocking him to the ground. And again, what they will tell you is that a struggle ensued where the officers jumped on Mr. Ellis, pushing him to the ground, started punching him and tasing him, and that all occurred right here in this intersection, right here in this part of the street here. You will see the videos taken by Sarah McDowell. She's here, and she has her cell phone video, and she's recording what's taking place right here. And you'll see the cell phone video from Seth Cowden, who has a different angle, and his angle is from here, and you'll see both of their videos in this trial. And what you will see in these videos is from Seth Cowden's video. What you will see is Officer Collins wrapping his arms around Mr. Ellis's neck, pulling him back. You will learn that this is an unapproved restraint. What he was doing was applying this technique called the LVNR. It cuts off the blood circulation to the brain, cuts off the carotids, and it causes the subject to go temporarily unconscious. This is a dangerous maneuver that the Tacoma Police Department does not allow their officers to be trained on. Yet Officer Collins went ahead and performed that chokehold anyways. What the video will also show is while Officer Collins is placing him in that restraint, you'll see Mr. Ellis hold up his hands, his arms, palms up in a surrender position as he's being jerked, is being pulled back and being choked by Officer Collins. And what you also see is Defendant Burbank with a taser out pointing at Mr. Ellis's chest. And Mr. Ellis is giving up, like, stop, give up. You'll see Mr. Ellis then pull back to the ground by Officer Collins. And when Mr. Ellis goes to the ground, he again raises his arms up in a surrender. And he's being choked at the same time. And what you'll see is Officer Burbank then fire a round of taser into his chest. And you'll learn that officers are trained not to target the chest because it's dangerous. But despite his training, he did it anyways. And that causes 50,000 volts of electricity to go into Mr. Ellis. And he's doing that as Officer Collins has Mr. Ellis by the neck, choking him. And what you will see is in the video is that Mr. Ellis reacts to the volt of electricity initially, but then he goes still, unconscious. You'll see his head drop because at this point, Officer Collins has successfully applied the LVNR and Mr. Ellis is unconscious. Mr. Ellis, you'll see, regains consciousness a few seconds later. He's now on his stomach with 2 taser probes underneath him in his chest, and he's pressed to the ground by the officers. You'll see Officer Collins on top of him. You'll see Officer Burbank with one of his knees on top of Mr. Ellis. During this, Mr. Ellis is in pain, and he's struggling, probably struggling for breath. And you'll see Officer Burbank slip off of Mr. Ellis. His knee comes off. And as that happened, he applies another round of 50,000 volts into Mr. Ellis. And you'll see Mr. Ellis's reaction. He screams. He's flailing from the pain of the 50,000 volts of electricity into his body. And he flails his legs in pain. But eventually, he stops moving. And you'll see Officer Burbank and Officer Collins on top of Mr. Ellis. At that point, the witnesses at the scene started to drive away. Seth takes a turn here and starts driving off. Sarah, in the meantime, went around the patrol car, and Mr. Ellis is here. And you'll see cell phone video footage by Sarah and Seth showing those 2 officers on top of Mr. Ellis after that second blast of taser. They have him under control at this point. He's not moving. They have him, they're on top of him. But the defendants are not done with Mr. Ellis yet. As Seth, Sarah, and Keon leave the scene, and just as they leave the scene, you'll learn that Officer Burbank applies a 3rd application of taser into Mr. Ellis. Mr. Ellis was underneath, pinned onto the ground by Collins and Burbank at this point, but Burbank applies a third round of taser. He did this even though he's been trained that you should apply the taser only when it is necessary to overcome active resistance by an individual. And you will see in the video that Mr. Ellis wasn't actively resisting. And he wasn't a threat. And he wasn't doing anything to deserve that third blast of electricity into his body. All four of these witnesses will tell you throughout all this that Mr. Ellis never fought back, never struck at the officers, and that it was the officers that were attacking him. And it's important, and it's important to know that police officers are trained that they can only use force if it is necessary to achieve a lawful purpose. Even if officers have a basis to arrest someone, if that person is not fighting them, they can't just start a fight. And even if a subject is resisting, officers can only use the amount of force reasonable to overcome that resistance. They don't get to just inflict pain because they're fearful or because they want to or because they're angry. If someone needs to be placed under arrest, their job is to just arrest him. And that's a phrase that you will hear from Ms. McDowell when she was yelling at the officers to stop hitting Mr. Ellis. She said, "Stop hitting him, just arrest him." That's what officers are trained to do, to just arrest an individual, not to strike them, assault them. But that's not what they did here. After the witnesses leave the intersection, we have no more cell phone footage to see. But we do have a doorbell camera at Miss White's house. And her doorbell camera captures important audio. She will capture, the video will capture the last words from Mr. Ellis. "30 seconds after Sarah, Keon, and Seth leave the scene, the doorbell camera captures Mr. Ellis. And he's saying, 'I can't breathe, sir.' (11:23:28). The doorbell camera captures Mr. Ellis saying, "Can't breathe, sir, can't breathe." A few seconds later, you'll hear the doorbell camera, Mr. Ellis saying, "Breathe, sir." In response, one of the two officers, Collins or Burbank, says, "Shut the fuck up, man." And you'll hear that in the audio. (11:24:52). you'll hear Mr. Ellis again. I can't breathe. This time, Defendant Rankine now is at the scene, arriving a few seconds before this. And Defendant Rankine is there to hear this. About 10 seconds later, you'll hear Mr. Ellis again. Can't breathe, sir. And again, Mr. Ellis is on the pavement in a prone position. At this point, after Officer Rankine arrived, he's placed in the hog tie restraints. He's now at this point in hog tie on the pavement. And he's saying, can't breathe, sir. This last transmission, 20 seconds later, is actually captured not on the doorbell camera, but from a radio transmission that one of the officers at the scene makes. At this point, there are a number of officers at the scene. The situation is under control. Mr. Ellis is prone on his stomach, hog-tied, with Defendant Rankine on his back. And in that transmission, you'll hear the officer saying, slow incoming, meaning all incoming units, you can slow down now. We have everything under control. That's the broadcast. And in that broadcast, in the background, Mr. Ellis, in a desperate voice, you can hear, says, still can't breathe, sir. And you'll hear that audio. One of the interesting things about all of this, about I can't breathe, sir, I can't breathe, we hear Mr. Ellis politely saying, can't breathe, sir. When Collins and Burbank were interviewed by investigators a couple days after this incident, they were asked specifically whether Mr. Ellis said anything. They both said no. They denied that Mr. Ellis has spoken any intelligible words. Instead, what they told investigators is that they described Mr. Ellis as growling and making animalistic noises, not saying anything verbal. Now, you'll be the judge of whether he was being animalistic, growling, when he's sitting, when we have this evidence. Can't breathe, sir. Sir, can't breathe. The evidence showed that Mr. Ellis said he can't breathe numerous times, but even once should have been enough. Even if Mr. Ellis said, I can't breathe, sir, once, that should have been enough for the officers to help him, to do something for him, but they didn't. You'll learn during this trial that police officers are taught that they have a duty to help people in their custody, because once a person is restrained, hog-tied, handcuffed.
I'm sorry.
I know the basis of the deal, and so I'm going to excuse the jury for just a minute. Ms. Jones, please do not discuss the case. Don't worry, we'll get it on the record. Yes, go ahead. Did Hannah go around to meet them? Okay. Okay. Please be seated. The objection, as I understand it, had to do with the use of
I'm sorry?
the use of the word hog tie.
Well, not as much, I mean, to some degree, Your Honor, but the issue that I was objecting to there was Mr. Liu getting into the training I believe Mr. Conrad laid out, and the court previously ruled that that was not something the court, that the state should do at this point.
If he can reasonably, he expects that the testimony is going to talk about the training of the officer. He believes that in good faith, and from my understanding of this, there is a good faith basis for that. There's no problem with that. With respect to the issue of hog tying, I mean, I believe Mr. Collins made a motion in limine with respect to that, and what I said was, if memory serves, something like, well, I'm not going to make it an order, but I don't want people to introduce gratuitously the term hog tie. This has been used at least 3 times, I believe, by Mr. Liu this morning. So on this third occasion, he just mentioned it, you raised your objection, I just assumed that that was what it was. Certainly he can indicate that he was bound, and you can describe how he was bound, but just try to avoid that word. I think it's a little bit loaded under the circumstances. I'm not going to find there's any violation of an order at this point. There isn't any. Anyway, any reason we can't have the jury come back now?
No, Your Honor.
We all understand where we are?
Yes, Your Honor.
Understand, Your Honor.
Yeah, go ahead. Let's have the jury back. See, this is the problem. This is when he can't get back there. Okay, you guys can all be seated. If you want to come back and stand up when the jury comes back in, that's fine. Or if you want to remain standing until they arrive, that's fine too. Shouldn't be too long. Mr. Liu, any rough idea how much longer you've got?
I'm sorry, Your Honor.
Any rough idea how much longer you've got?
I'm sorry.
Any rough idea how much longer?
Oh, 20 minutes.
20 minutes? That should work, because I'm looking at when the break's coming up. 20 minutes should be fine. I don't want to interrupt it unnecessarily.
Thank you, Your Honor.
I'm not hearing what you guys are saying, so. Okay, welcome back, everybody. Please be seated. You set? There we go. Mr. Luke, continue when you're ready.
Thank you, Your Honor. Before the break, I was talking about the police officer's duty to help people in their custody. You know, once someone is restrained, they can't help themselves. They can't move themselves to a better position if they can't breathe. And police officers are trained to pay attention to people in their custody and control. That they have to take care of them to make sure that they can breathe. And the evidence will show that these three defendants did nothing to help Mr. Ellis. Even as he pleaded with him over and over again, can't breathe, they did nothing for him. Instead, what do? They keep him on the ground, on his stomach, and they grab a hobble cord, wrap it around his ankle, ties it to his handcuffs that's behind his back. And you will learn that police officers are trained about the dangers of prone positioning because it can lead to something called positional asphyxia. It's where the body is positioned in a way that it restricts their breathing and it prevents the body from getting the oxygen they need. Police officers are trained on that. And police officers are taught that putting someone in the prone position on their stomach is a transitional position. That you could put someone in the prone position to handcuff them, but you should immediately get them up, sit them up, put them in the patrol car. You don't just leave them in the prone position. But these three defendants disregarded their training. Even after hearing Mr. Ellis say, he can't breathe, and even as he was struggling to breathe, they left him on his stomach, restrained, with his ankles tied together with a strap connected to his handcuffs in that position. Now, you will hear the defendant say, well, he was still struggling, he was still moving around. But you will learn from an expert in this case that it is akin to someone drowning. When they're desperate for air, when you're struggling to breathe, you'll struggle, try to move to get air. And that's what was happening to Mr. Ellis. He was prone on the ground, already telling the officers, can't breathe, sir, can't breathe, numerous times. He was struggling to breathe. The fire department did not arrive until 11:34. Fire didn't get there until 11:34. Close to 10 minutes after Mr. Ellis last said, still can't breathe, sir, over that transmission. What happened during those 10 minutes? You will learn that Defendant Rankine, in his statement to the investigators, that during those 10 minutes, he kept Mr. Ellis in a prone position on his stomach, hogtied with his own weight on top of him. You'll hear his statement to the investigators that Mr. Ellis was in 4-point restraints. Again, ankles being bound together, strapped to his handcuffs. And he said in that position, he got on top of Mr. Ellis, pressed him to the ground because somehow he thought Mr. Ellis was still a danger. Defendant Rankine will tell you that he will say during the statement to the investigators that he briefly rolled Mr. Ellis to his side to sweep for weapons. Finding none, he then says, well, Mr. Ellis started thrashing around violently. So he rolls Mr. Ellis back onto his stomach, then reapplied on top of him and reapplied pressure on him until fire got there. So except for a brief moment when he's checked Mr. Ellis for weapons, Mr. Ellis was on his stomach in the prone position with Officer Rankine on top of him for all that time. That was 10 minutes. In fact, he told the investigators that as fire arrived, I still had control of the guy's upper body. My right knee was around the right shoulder blade area of him, and my left knee was on the middle of his back still. Medical experts will tell you that by that time, by the time the fire arrived, it was too late. Mr. Ellis had already been starved of oxygen to the point that they couldn't revive him. And during those 10 minutes, Officer Burbank and Collins remained on the scene in this area. And they did nothing to help Mr. Ellis. You will learn that a total of 20 officers arrived at the scene eventually from several different agencies. And you will hear from many of those officers regarding their observations. And to put it frankly, their observations and descriptions of what they saw is all over the place. For example, they had different testimonies regarding whether Mr. Ellis was having trouble breathing or not. They couldn't agree what position he was in. Was he on his side? Was he on his stomach? In fact, one officer said he was on his back. But we know what position Mr. Ellis was in because Officer Rankine, the officer that was hands-on with Mr. Ellis, told investigators that. There are many contradictions between these officers about what they saw, and you'll be the judge of their credibility. You'll also hear about a decision to put a spit hood on Mr. Ellis. The spit hood is issued by the Tacoma Police Department, and it comes with a warning. And the warning says that the spit hood should not be used on anyone having difficulty breathing. Yet a spit hood was put over his head, and the people that knew he was having difficulty breathing, Officer Collins, Burbank, and Rankine, heard him say, "Can't breathe, can't breathe," yet they did nothing as that spit hood was placed over Mr. Ellis's head. And Mr. Ellis was bleeding at that time, and you'll hear a description by one of the officers at the scene. In fact, the officer that put the spit hood on him. All three of these officers, all three of these defendants knew that Mr. Ellis couldn't breathe, was having difficulty breathing, but they did nothing and just stood by and allowed this to happen. In fact, after Mr. Ellis died, 8 hours after his death, the medical examiner examined that spit hood, and he found that the spit hood was covered with blood and mucus from Mr. Ellis's nose and mouth. And the medical examiner determined that that mask played a significant factor in Mr. Ellis's death. During this trial, you'll also be asked to determine the credibility of Officer Burbank and Collins. They provided statements to investigators after the incident. Officer Burbank and Collins, you'll hear, claim that Mr. Ellis wasn't walking on the sidewalk as witnesses will tell you, but he was in the middle of the intersection here, trying to get into a moving car, trying to open a car door. Now, they will tell investigators that they thought it was possible carjacking or domestic violence situation. They didn't know. Yet, Officer Collins in this statement says he rolled down his windows and told Mr. Ellis to come on over to his patrol car. You'll learn that this isn't protocol. It's dangerous. Officers are trained not to do that. And you also learn that they didn't radio in their stop until after Mr. Ellis had been tased and the LVNR was applied. If they suspected that Mr. Ellis was performing a carjacking, they would have radioed in immediately, but they didn't. And you also learn that Officer Collins, during his statement to investigators, said that as he got out of the patrol car, he ran around the front of the patrol car, and Mr. Ellis was over here on the passenger side. And he will claim that Mr. Ellis lifts him up by his vest into the air and throws him backwards into the street. This is a proficient, experienced grappler. He's an experienced police officer, and you'll learn that he weighs about 200.
Overruled. Continue.
And you'll learn that he weighs about 230 pounds. And he says he was thrown back into the street by Mr. Ellis. None of the eyewitnesses, any of the 4 eyewitnesses see this happening, and you won't see that in the videos. Officer Collins also in his statement said he attempted to apply the LVNR, but didn't actually go through with it because Officer Burbank tased Mr. Ellis at that point. He says he only attempted. And you will see in the videos that Mr. Ellis passes out from the LVNR. He goes unconscious, he goes limp, and his head drops to the ground. Officer Burbank will tell the investigators that Mr. Ellis had a jug of water in one hand, something else in the other. And we know that's probably the donuts. And he will claim that he was trying to get into a car in the middle of the intersection with these items in his hands. And he will also tell you that during the incident, after he had door checked Mr. Ellis, he got out, and he will tell you that Mr. Ellis chased him 10 to 15 feet into the intersection, screaming and growling, flailing both fists at him, and in jumping type motion, they collided and went down to the ground. Videos don't show this. None of the eyewitnesses will tell you that this happened. We don't see, and we don't know what happens, after this last footage at the scene until fire arrived, as I mentioned, except for one thing. Ms. White actually takes a cell phone video from her house about 1 minute prior to fire's arrival. And you'll see that video where she's scanning the street, and she'll scan over to the intersection, and in her video you'll see a number of police officers standing around Mr. Ellis, talking casually while Mr. Ellis is on the ground with Officer Rankine kneeled on him. This video was taken from her house, and again, what it shows, and it's a little blurry, but you'll be able to see this. You see Officer Rankine in a position near Mr. Ellis's upper body. And recall what Officer Rankine said. He said that as fire arrived upon the scene, I still had control of the guy's upper body. My right knee was around the right shoulder blade area of him, and my left knee was in the middle of his back still. This is what we believe Ms. White's video shows. And this was taken 1 minute prior to fire's arrival. When the fire department arrived, they found Mr. Ellis still had the spit hood over him. He was still restrained. And they knew that the situation was dire, and they wanted Mr. Ellis, the restraints on Mr. Ellis, to be removed. But what was the response? Officer Rankine actually resisted, telling them that he believed Mr. Ellis was still a threat at this point. Incredibly. So they had to get a sergeant involved in order to get the restraints off Mr. Ellis so that the fire department could finally start working on him. And when the fire department started working on him, he was barely breathing. His pupils, as I mentioned before, fixed, dilated. He had shallow breath that ceased, and he went into cardiac arrest. The fire department hooked Mr. Ellis up to a heart monitor, and the heart monitor showed that he had electrical activity but no pulse. This is a condition called pulseless electrical activity. And you will learn from the medical experts that hypoxia, or lack of oxygen, causes PEA, pulseless electrical activity. And despite the fire department's efforts, they spent 40 hours trying to revive Mr. Ellis. He was pronounced dead on 96 and Ainsworth. The next morning, the medical examiner, an autopsy was done by the medical examiner on Mr. Ellis. And you will hear from medical experts by the state. And they will tell you that they all concluded Mr. Ellis's death was caused by hypoxia, lack of oxygen, due to the actions of the defendants. You will hear from a forensic pathologist. You'll hear from an expert on the heart, expert on the lungs. You'll hear from a pulmonologist. You'll also hear from a police surgeon and an epidemiologist. All of these medical experts will testify, and all of them will tell you that they agree with the conclusion of the Pierce County Medical Examiner's Office that Mr. Ellis died from hypoxia due to the actions of the defendants. Now, you will hear the defense argue that Mr. Ellis died not from hypoxia, but from a meth overdose or his heart condition. However, the experts will tell you that death from an overdose or heart condition doesn't cause PEA, doesn't cause a slow death like you have here. It's a more sudden death. Now, before I finish, I do want to take a minute to talk about what the defense may argue in this case. And keep in mind that the defense has no burden. The burden is on the state to prove these charges to the case beyond a reasonable doubt. But I do anticipate that they will make certain arguments. For instance, they may talk about a smear that's on the passenger window that they will argue is evidence of powdered sugar, to support their argument that Mr. Ellis had somehow had punched the window of the passenger side. Of course, none of the witnesses see this, and that smear was never processed, so we don't know what that smear is. And you also see a photograph of the donut box at the scene. And that donut box was stepped on, but it was never opened. It was still closed. You may also hear the defense attack the credibility of those eyewitnesses, suggesting that they're unreliable because they didn't immediately come forward with their information. You'll learn that Seth Cowden and Sarah McDowell didn't come forward with the videos until sometime after Mr. Ellis' death. And of course, they didn't know that Mr. Ellis died. Sarah McDowell will tell you that she didn't realize what she had seen, what she had filmed that night, was the death of Mr. Ellis until after she saw social media postings about his death. And that's when she came forward with her video. You'll hear from Seth Cowden that he didn't realize what he had also until he read about Mr. Ellis' death in the newspaper. So then he reached out to Mr. Ellis' family lawyer to tell him, I have this video. Same thing with Sarah McDowell. She reached out to Monet because she realized what she had. And defense will try to argue to you that somehow this makes them unreliable. Yet the defense won't be able to explain how any of these eyewitnesses who didn't know each other, who didn't know Mr. Ellis at the time, captured their video and gave you consistent accounts of what occurred at that intersection. And all of them will tell you that it was the officers that attacked Mr. Ellis, that Mr. Ellis never attacked them or was aggressive or violent towards the officers. Now, finally, you will hear the defense put Manuel Ellis on trial. As I mentioned earlier, Mr. Ellis did struggle with addiction, and you will hear
First, argument and proper argument in opening statement, and second, indicating that there's any burden of proof on the defense, or that we have to present anything, or that we will.
Overruled.
Thank you.
Continue.
And you will hear that Mr. Ellis used methamphetamine that night. And you'll hear from the defense about an incident that occurred in 2015 where Mr. Ellis was arrested with a needle in his back pocket. You'll hear that Mr. Ellis got upset when the police found it and struggled with the police ensued. And he was eventually hobbled, handcuffed, and put in 4-point restraints. And I mentioned before the 2019 incident where he was naked on the street. What the defense want you to believe and what the defense hope to accomplish is to have you assume that just because Mr. Ellis acted in a certain way in 2015, 2019, that's how he acted that night of the incident. But you will hear the evidence, you will hear the witnesses, you will see the videos, you will hear the audios. All of the witnesses that interacted with Mr. Ellis that night will tell you he was his calm, happy self, that he was having a good night. He went to church, played the drums, came home, talked to Tiana, Alexis, talked to Brandon, talked to Marcia. He recorded himself performing a rap on his phone with Bible verses, and you'll see that he was calm, he was happy. And you'll hear, more importantly, from the eyewitnesses at the scene who will tell you that Mr. Ellis was just walking on the sidewalk when he was attacked by the officers, that he wasn't violent towards the officers, that he didn't strike back, that he didn't assault any of the officers. Not only that, you have the videos taken by Sarah McDowell and Seth Cowden that showed Mr. Ellis being assaulted by the officers. Seth Cowden, you'll hear, described it as seeing Mr. Ellis being ragdolled by the officers, and that's what you'll see in the videos, that Mr. Ellis was being ragdolled. And you'll hear the audio. You'll hear Mr. Ellis pleading politely with the officers, "I can't breathe, sir." This is the picture. This is what happened that night versus what they want you to believe, that just because he acted in a certain way back in 2015, 2019, that he acted the same way that night. And that's simply not the case. Ladies and gentlemen, that is the evidence that the state expects to show you during this trial. You will hear from the eyewitnesses. You will see the videos. You will listen to the audio. And you will hear from the experts, the medical experts, who will tell you that Mr. Ellis died not from a drug overdose or his heart condition, but he died from oxygen starvation caused by the actions of these defendants, caused by the assaults on him, by the extreme restraints placed on him, by being placed in the prone position with Officer Rankine on his back. And he died because none of these officers listened to his pleas, his cries for help. They ignored his pleas that he can't breathe. And they chose to keep him in that position, on his stomach, restrained that way with Officer Rankine on his back until he starved of oxygen and he died. You will hear descriptions of Mr. Ellis as growling, acting animalistic, or making animalistic noises. The evidence will show that Manny Ellis was a human being that loved his family. He was flawed. He struggled with addiction and mental health, but he was trying to change his life. He was not an animal, and he deserved the respect and the care that was not given to him when he died that night at the intersection of 96 and Ainsworth. At the end of the case, the state is going to ask that you listen to Mr. Ellis's words. That will be his testimony in this case. And at the end of the case, the state will ask that you return verdicts of guilty as charged on all three defendants. Thank you.
Okay, we'll take our morning recess this time, hopefully for 15 minutes. Please do not discuss case among yourselves with anyone else, and do not permit anyone to discuss case with you in your presence. So we're at break.
He's starting to test me now. He's starting to test me, thinking,
Yeah, you don't want to go into the lunch hour. Everyone gets
that's true.
hangry.
All please rise. Please reconvene.
Okay, welcome back, everyone. Please be seated. Okay. At this point, it's my understanding, Mr. Purcher, you're going to make the opening?
Yes, Your Honor.
And is Collins going to reserve? He's still? Okay. And then Rankine?
We will be giving an opening now.
Great. Well, I'll still ask you guys in case you change your mind. Let's have the jury.
What's that? Try not to. Are they insured? Are they insured? In the car that I was going westbound. Yeah, he was trying to left turn there. Yeah. Okay.
Welcome back, everybody. Please be seated. Okay, Mr. Purcher, you're going to make your opening statement. Okay, ladies and gentlemen, please give your attention to the opening statement of Mr. Brett Purcher on behalf of the defendant, Christopher Shane Burbank. Mr. Purcher.
Thank you, Your Honor. May it please the courts, members of the jury, counsel, importantly, Officer Burbank, Officer Collins, and Officer Rankine. Mr. Liu spent the past hour and 15 minutes talking to you about an event that lasted less than 2 minutes. The Manny Ellis that he talked to you about is not the Manny Ellis that faced Officer Burbank and Officer Collins on March 3rd, 2020 around 11:30 at night. On that evening, the Manny Ellis that they encountered was aggressive, he was violent, and he was extremely high on methamphetamine. After taking almost 2 minutes to try to arrest him and detain him, he was still bucking and fighting even after they had handcuffs on him. During that period of time, Officers Rankin and his partner, Officer Ford, happened upon the scene with a tremendous number of other officers, and Mr. Ellis is still bucking these individuals, still fighting against these individuals. That is the Manuel Ellis that these individuals encountered. And I mentioned the methamphetamine not because of some fiction that's involved here, but that's exactly what the situation was. The autopsy was done by the Pierce County Medical Examiner, Thomas Clark. It was done on March 4th, the day after the event. There was a toxicology lab request that went out. That lab request came back in the middle of May, and Dr. Clark's report in the conclusion was as follows. The methamphetamine concentration is well within the fatal range and could have caused the death independently. He talks about there's a possibility of hypoxia, but then concludes his statement on the opinion of his paper. An argument could be made that the extremely high methamphetamine concentration should be considered the primary factor. You know, regrettably, Mr. Ellis died, but it was nothing that any of these officers did. Mr. Ellis died, unfortunately, of his methamphetamine toxicity. And at the conclusion of this case, when we're back before you during closing arguments, we will indeed ask that you find all of the officers not guilty for any of the crimes for which they're charged. Now, you need to know a little bit about the individual in this case. Officer Burbank was with the Tacoma Police Department for 5 years. Before that, he was with the Salem, North Carolina Police Department for 5 years. Before that, he was an infantryman in the United States Army for 8 years, serving tours in Iraq. Officer Collins, also with the Tacoma Police Department for 5 years. Before that, he was a United States Ranger individual for 8 years, serving several tours in Afghanistan. Both individuals came to the Tacoma Police Department at roughly the same time, and they became partners. Their area was 96th Street, basically Sector 4 in the city of Tacoma. 96th Street is one of the borders. It goes to the Puyallup, Portland Avenues on the northern side. This is a tougher area within the city. There's a lot of crime in this area. There's a lot of drug use. It's just a tough situation. But this is an area that the officer patrolled, and he patrolled it professionally. They worked the graveyard shift, which is about 8 o'clock at night till 6 in the morning. And their goals are twofold. One, to do our job professionally, to return home to our families at the end of our shift. That has been their goals for the 5 years preceding the state. That would still be their goals. But unfortunately, on this particular night, Mr. Ellis had a different idea. Now, with respect to you've heard some testimony about video and what had occurred, but this is for purposes of explaining everything that occurred and to put it in some type of a context. Earlier that evening, Officer Burbank and Officer Collins had done a traffic stop, an infraction, at 8th Street and 96th. Now, just to give you an orientation, 96th Street, it goes west, east and west. Ainsworth is a north and south tributary. 8th Street would be, a mile or so down to the east of this intersection, and they stopped two individuals, a young lady and her mother, both black females, had some issues with respect to a light that was out. They talked with these folks, said take care of the problem and move on. After that, the officers patrolled up to 96th and Ainsworth. Now, significantly, when they are at the A Street location, 96th and Ainsworth, or excuse me, in A Street, they were teamed up at that point in time with officers Rankin and Ford. They were also in a two-man patrol car. Officers Burbank and Collins were in a two-man patrol car. They met in that location. The event was taken care of regarding the infraction. No citation given. Let the folks go. Rankin and Ford went the opposite direction. Collins and Burbank went up there to the intersection of 96 and Ainsworth. Now, when they got there, when they got to the intersection, they noticed a vehicle basically coming off of Ainsworth and trying to turn westbound onto South 96th. The problem, what they noted though, is that there was an individual that was out there in the intersection with that car, and they couldn't tell what the heck he was doing. He was waving his arms in front of the car. He went to the door. It looked like he was trying to get in the passenger side of the vehicle. and the car drove away. They didn't know it was a domestic issue, carjacking, what it was. If he was a passenger in the vehicle, they had no idea. But as they were sitting here, Officer Collins is on the driver's seat, Officer Burbank is the passenger, said, hey, guy, come over here. What's going on? Who later became known as Mr. Ellis comes up, I've got some problems, I've got warrants out. He was speaking super rapidly. He was in a bit of distress, but they didn't know what was going on. Officer Collins says, look, go to the curb, and we'll contact you. And the reason you do that is police officers, they don't want to be caught in their vehicle when there's a person outside that can have basically an upper hand of these folks. So he said, go to the curb and we'll come contact you. As Mr. Ellis goes around the front of the vehicle, he fixates on Officer Burbank. He fixates on Officer Burbank. He comes up to the passenger side of the vehicle. Officer Burbank doesn't know what's going on. He starts to roll the window down. And Mr. Ellis says, I gotta punch you in the effing face. Immediately, Officer Burbank realized this is going sideways, and he's pinned in his vehicle. He rolls his window back up the same time that Mr. Ellis is beating on the window, hits it with 2 or 3 punches. Mr. Ellis goes for the passenger door. Officer Burbank locks the door and gets out. While he's doing that, and this is a rapidly transpiring event, Officer Collins, who's on his mic, is getting ready to inform dispatch of what is going on. He gets a mic click and he is out of the car before he can announce what it is that they are doing and where they are. As he comes around the car, from the bow of the car, he comes around the corner. Mr. Ellis is at the passenger window. Mr. Ellis turns his attention from Officer Burbank, shifts it to Officer Collins. His fists are clenched, and as Officer Collins is in front of it, Mr. Ellis is coming toward him. Officer Burbank opens his door to try to distract Mr. Ellis from going after Mr. Collins. It doesn't work. Mr. Ellis goes up, grabs Mr. Collins, and throws him to the ground with superhuman strength. It's something that these officers have not faced before, but it's something completely bizarre. He is on top of Officer Collins. Officer Burbank gets out of the vehicle, and the two of them are grappling with Mr. Ellis. Now, the reason that part is important and significant is because there is video of this interaction, but it occurs well after the initial confrontation begins. Officer Collins and Officer Burbank are engaged with Mr. Ellis, trying to defeat what it is that he's got in his mind, because they cannot tell. It gets to the point where Officer Burbank gets knocked away from Mr. Ellis. He goes, I've got to use something more because I cannot handle what it is he's doing, and he uses his taser. He shoots him with the taser. It has an effect temporarily, but when that effect wears off, it's like a 5-minute spurt. Mr. Ellis is back engaged with Officer Collins. A short time later, he engages again with the taser. It's still not working as he would expect it would work on any other individual. And during that same period of time, or close in time, Officer Collins is trying to put a lateral neck restraint onto Mr. Ellis to subdue him, and that is not working. He cannot get it done. Officer Burbank then shoots another taser round. That one gets him to the bottom where he's on top of him, and they are finally trying to get his arms. Trying to get his arms so they can handcuff him and restrain him. And he's getting jostled, both officers are getting jostled around by Mr. Ellis. They are not in control of the situation. They are panicked about the situation because this is a tiring event. During the period of time that Officer Burbank is there, he's clicked his mic, he's clicked it twice, and then finally he screams out, 96 in Ainsworth. And you'll hear that on the dispatch. Now, the significance of Officer Burbank's call out is that Officer Burbank and Officer Collins are known as two of the more adept, calm, quiet officers, extremely professional, don't get excited about events. When other officers heard this cry on the dispatch, they were concerned that they were going to come to the scene at 96 and Ainsworth and be witnesses to a fatality of the officers. That was the concern that they had, because Officer Burbank's call out was so unusual, so unlike anything that anybody had experienced before. That was the concern that the officers had. When the mic clicks go on, you will see, and you're going to hear the dispatch that's going on during this period of time. High intensity event. Officers Rankine and Ford, who have heard the clicks, turn around and are racing back to the scene. When they get there, Officer Collins and Officer Burbank are in front of the vehicle. They stop and they come to assist. Now, it's significant. Officer Rankine is on Mr. Ellis. Officer Ford is on Mr. Ellis. They have him handcuffed, but they don't have him stopped. They simply do not have him detained yet, and that is the first priority that an officer has in responding to a scene, is you control the scene. And you're going to hear more about that here shortly, but that is their first priority, and the scene was not in control. In this 2-minute period of time, there are 8 to 10 other officers that arrived, including Officer Burbank and Officer Collins' supervisor, who would take control of the scene, and they are still trying to get Mr. Ellis under control. They are in a fight. They are exhausted. They have other folks that are helping, other officers that are helping with detaining Mr. Ellis, but it's not working. He is still moving. He's thrashing. They ultimately put a hobble on him because he's kicking. They ultimately put a spit mask on him because he is spitting, and that's the nature of this event. There were probably 15 to 20 officers there before Mr. Ellis was under control, but that was long after the 2-minute period of time that Officer Collins and Officer Burbank were involved with Mr. Ellis. When the other officers arrived, Officer Burbank and Officer Collins were away. They heard the call for the hobbles. They went and got the hobbles and helped other officers assist. But at that time, there's 5 or 6 different individuals that are present, that are in place on Mr. Ellis. That is the circumstances that gives rise. Now, you've heard the references to the videos, and indeed there are videos. There's 4 videos. We have the videos from Sarah McDowell, who came up to the scene. Her parent, or her kid's father, Keon Lowry, is behind her. They are going from their prior place where they're at to Sarah's sister's house, which is about a mile away. And they have Seth Cowden, the pizza delivery driver, who is getting ready to take a right onto South 96th. And they have Ayanna White. Now, and this is Ayanna's home here. Significantly, there's videos from these 3 different individuals, but they come at different points in time of the encounter. We know that for a couple of reasons. One is that you can tell based upon just when they shoot the video, and thinking about your own personal situation, the time it would take to train your camera, to get your camera working, and taking a look at the situation. But also based upon what the officers are doing at the time that the videos occur, and also the length of time that the videos last. Now, Miss McDowell comes to the scene, says, "You're hurting him, just arrest him," all right? Mr. Lowry's behind her. He gets out of the car. Miss McDowell's video transfers from the officers, and she's picking on Mr. Lowry, telling him to get back in the car. He's got his daughters there. Don't be irresponsible. That's her response. She pans back up to the scene and catches the officers again. Mr. Cowden, who arrives at the scene, sees the interaction of the officers with Mr. Ellis, but again, it's after the event has started. The initial part of the event is not captured by any individual. Ayanna White is also, she's awakened from, she's playing on her phone or whatnot. She looks out the window, observes what's going on, takes some video of the situation, but all of it is inconsistent internally with each other. Miss White will testify that she saw Mr. Ellis pick up and knock Officer Collins to the ground as part of the part that she saw. And that's the people that are with the videos. Now, there's 3 other important parts to this. One is that this house, Ayanna White's house, has a Vivint doorbell camera that's fixed to the house. This is one of those motion-activated cameras that if there's motion, the camera starts and it picks up the scene. Significantly, it doesn't pick up the car traveling through here. it picks it up some point in time after the effect, and so you see no cars, and then you see a car. There is a period of time that passes that you don't have any video of what is occurring. But it's clear that it's capturing, the events after the fact. But also importantly, there's two other individuals that the state failed to mention. Shad Hayes and Kenneth White. Now, Kenneth is Ayana's brother, also lives in the home. He heard the commotion outside. He gets up, he looks what's going on. He's a former Marine. He's familiar with the kits that the officers wear. He's familiar with the weight of the kits. And he's watching as Mr. Ellis is moving these guys around like nothing, like he is moving as these officers are trying to restrain him. That's the one thing that he says. And he's noting that these guys are having some difficulty, but they're still grappling with him. He ultimately goes back in. Now, the other individual is Shad Hayes. And Shad's house, I believe, is this house right here. It's 1433 South 96th Street. Shad hears Miss McDowell scream. That gets his attention. He looks out. He sees what's going on. He comes outside, and he sees Mr. Ellis basically manhandling both Officer Burbank and Officer Collins, such that he asked them if they need his assistance to apprehend Mr. Ellis. They tell him, officers are coming, we don't need it. And so Mr. Hayes, and you will see him on the video, is out directing traffic because the officers and Mr. Ellis are out on the road. He doesn't want their cars that are coming through this way to strike them. And so that's his involvement. But you have these independent folks that are testifying about what it is that they see occurring on that late evening night, getting closer to the morning. Now, as we go through this, there's really three parts to this event. The first is, as I've explained, is the factual situation. What's the outlining, the background facts that give rise to this case? That's the first part. The next part is there's expert testimony that's going to be presented to you. Both the state have experts and the defense have experts. And that's regarding use of force. What was the appropriate amount of use of force? Now, it's the state's contention that officers Burbank and Collins would be on the force that they would be allowed to use under this particular circumstance. And respectfully, I would suggest that is wrong, for one. And it's wrong for a couple of reasons. One is that the experts that they rely upon for purposes of the opinions, they kind of give a half opinion. There's two of them. There's Sue Peters and there's Jack Ryan. Now, Miss Peters she's credentialed. She's a law enforcement officer. She testifies a lot and she provides information. When the case was charged, Miss Peters' opinion for officers Burbank and Collins is not regarding the use of force, not regarding the force that they used, but that they didn't call for medical assistance in a timely fashion. Let's step back a bit. What I just told you is that Officer Collins and Officer Burbank were engaged with Mr. Ellis for less than 2 minutes. They were exhausted after this fight. Other officers came in, and Mr. Ellis is still fighting, is still resisting these, such that they needed to put the hobbles on him. They needed to put the hobbles on him to restrain him. And still he's fighting these folks. To the point where when Officer Rankin is there, he has to continually apply pressure to him to get him to knock it off. And officers saying, don't resist, don't fight, quit fighting, quit resisting, routinely to Mr. Ellis is having zero effect on him. That is going on throughout that encounter. That's the one part. The next part is that Jack Ryan testifies a lot, provides testimony in a variety of cases dealing with use of force. He's selective in what it is that he considers. Selective in what he considers. He considers the videos that were taken by Ms. Sarah McDowell, by Mr. Cowden, focuses on those two, plus their statements. And that's basically what he considers. And then he sees the officers' reports from Burbank and Collins. He completely ignores Shad Hayes and Kenneth White, who provides some countering statements to these folks. And his opinion says, well, their use of force approximately caused Mr. Ellis's death. And that is where the state is bringing this case as well. You shouldn't have engaged him in the first place. You should have known for some reason that he was having some type of medical crisis, and you should never have engaged him, which is difficult to accept, but that's really kind of their position. Conversely, the defense we have, there's two experts. There's Chris Nielsen and there's Thomas Burns. And Chris, actually, Sergeant Nielsen, will be testifying regarding the events of Officers Burbank and Officer Collins. And in order to understand what Sergeant Nielsen's background is, you need to know who he is. Sergeant Nielsen is a police officer with the city of Renton. He's been there for 13 years. He's a trainer. He's been on the SWAT team. He's a person that engages with a tremendous amount of officers, and he has the knowledge for purposes of how to examine, how to consider these particular events. He's also a lawyer. He graduated from the University of Syracuse and he's been practicing as a lawyer for 18 years. In his progression, before he became a police officer, he was trying cases at the King County Prosecutor's Office, both misdemeanor and felony cases, and has that legal experience that is certainly helpful to those folks that are involved in law enforcement, and certainly helpful in this particular case. When Officer Sergeant Nielsen receives the material in this case, he steps back and says, okay, what do I need to do? How do I go about assessing the evidence that is being presented to me? How do I do that? Well, he goes back to his training, his experience, his teachings, and the first thing that an officer is to do is they prioritize what it is that has to happen in any particular event. First thing that you do is you secure the scene. That's priority number one. You must secure the scene. You secure the scene for the officers involved, for the individuals who are having contact with the officers, and for other civilians that might be in the area. You secure the scene first. You need to complete priority one before you go to priority two. Priority two is to provide medical aid, and priority three is to investigate the event. In this particular case, in going through the use of force pyramid, you may have heard of that. There's a pyramid of use of force. The highest level use of force is that of deadly force. We were well below that. But he says that based upon the training and experience that the officers have in his review of the evidence here, the officers did nothing inappropriate whatsoever because they were still engaged in making the scene safe. They were trying to make the scene safe because they're still in the process of apprehending Mr. Ellis at the time that the other officers arrived, including the sergeants that were responsible for taking over a scene when you have those type of events where multiple officers arrived. And it wasn't just the Sergeant Lim that arrived. There was two Pierce County Sheriff deputies. One was a sergeant, one was a lieutenant, who were also involved. And they were observing what's going on, and then ultimately they contacted medical once the scene was secure, once Mr. Ellis was apprehended, once he was secured. And he was still battling back and forth. Officer Rankine was dutifully watching over Mr. Ellis, and kept saying, settle down, we're going to take care of you, settle down. As soon as you settle down, I'll roll you over to your side. As soon as he did that, Mr. Ellis erupted again, and he put him back in the prone position. That was the environment that these individuals had during that period of time. So the conclusion of Sergeant Nielsen is that the officers did nothing wrong. They absolutely did nothing wrong. Their use of force was appropriate under these circumstances for the reasons I've stated. And that's just a simple summary of what it is he's going to say. When he gets on the stand, he will detail his experience, his background, his legal education, the whole 9 yards as to why this makes sense under these particular circumstances. And I ask that you consider his testimony along with the other person's testimony in ferreting out the evidence of the case. The next part, and frankly you don't need to get to this part, because if the use of force is appropriate, unfortunately when Mr. Ellis passed away, that happened. But quite frankly, based upon the testimony of the medical experts, that was more like a foregone conclusion than anything else. Now, remembering back, the medical testimony that's being provided from the variety of experts, and there's like a dozen experts or so. There's 6 on the prosecutor's side, there's 6 on the defense side, but they all point back to the initial medical evaluation that was done by Dr. Clark. Now, Dr. Clark, you'll hear him testifying, he'll be up on the stand. Dr. Clark was a former Pierce County medical examiner. And you're going to hear about his background and his experience and dealing with cases of this nature in the past. And all of the experts start that basically as their primer for what occurred. And Dr. Clark said that Mr. Ellis had a bad heart, and you're going to hear about that probably ad nauseum, that he might have been, it was progressive hypoxia, but the problem is that what put Mr. Ellis over the top was the use of the spit. That is significant because none of these three officers in any fashion had anything to do with the spit. That's the first thing. They had nothing to do with the spit. That was minutes after they had been done. They were no longer involved. And the other part, and it's significantly, is that due to Mr. Ellis's extremely high, fatal methamphetamine dose, he was going to die. Now, what's that mean? Well, there's testing that we talked about, I talked about earlier, that the methamphetamine level was 2,400 nanograms per milliliter blood. That's what the level is. To give you an idea of the lethality of that, people are known to die at 50 nanograms. 50. That's less than a tenth of what was here. Mr. Ellis was said by the state to have been acting normally that day. Well, we have testimony from what I consider objective individuals. There are two individuals from the state of Washington toxicology lab. There's Dr. Fiona Cooper and he's Lewis. They're toxicologists. They know about ingestion of this type of these levels of methamphetamine, what it can do to the person. And both are surprised at this level because of the significance of it, and from their experience, the levels and also the levels that's noted in the report that accompanies the report that Dr. Clark talked about, says 600, 800 nanograms is fatal. Mr. Ellis was 3 to 4 times higher than that at this point in time. So that's one problem. The other issue is that we're debating what Mr. Ellis was doing before he came into the encounter with officers in Burbank and Collins. He was anything but okay. The testimony that will come in from Dr. Cooper is that when you take a look at a particular drug level, you look at a couple of different things. One is you look at what the drug level is, and then you look at what the metabolite is. Now, in this case, the methamphetamine level was 2,400 nanograms. The metabolite, which is amphetamine, was in the low 40s. What that suggests to her is that this was a dose of methamphetamine that Mr. Ellis ingested within a half hour to maybe up to 2 hours before he came into contact with law enforcement. That is the significance of that particular amount. Now, the other part that makes it even more significant is that the doctors are going to testify that Mr. Ellis had a bad heart was from his chronic methamphetamine over a decade. He was in and out of the hospital with that issue, bad heart issues, a tremendous amount of just poor health, focused though primarily on the heart and his use of methamphetamine. And so the problem with that is that when you get these combinations and you have you're tolerant to methamphetamine, if you stop for a period of time, that tolerance wears off. It doesn't last. Now, you're going to hear testimony that Mr. Ellis, at this point in time, was in a drug rehab program in Pierce County Alliance, and he's living in this safe and sober housing unit, for ostensibly to stay safe and sober. But he wasn't maintaining it. He simply wasn't maintaining the sobriety. He had the event that we'll talk about a little bit more in September 2019. He tested positive again in December of 2019. And then we have the event here in March of 2020. So each 3 months, he is testing positive. But the question is, well, okay, he was sober for those 3 months. What does that do to a person's their ability to handle this load of methamphetamine? Well, if indeed he was completely off the drug, this level of methamphetamine will put him into a meth psychosis to where he's not going to recover from. That's what the situation, and that's what Mr. Ellis found himself in. Getting back to the medical experts, we have the testimony that starts with Dr. Clark's opinion. Now, he got some additional information, and he became the state's expert. After no longer working for the city, or for Pierce County, he became the state's expert. But he's stuck with this particular report. And not only is he stuck with this particular report, the other doctors are also comparably stuck, because all of the doctors on the state side say that we agree with what Dr. Clark says. We agree with it. Well, if you agree with what Dr. Clark says, then you need to agree that the methamphetamine dose was toxic, that it was a lethal dose, and that in and of itself could be the cause of Mr. Ellis's death. But they don't do that. They don't do that. And just for an example, there are of the doctors that looked at the methamphetamine, they have a kind of a range as to what their testimony, I anticipate, will be. One said, yeah, I acknowledge, and this is a Dr. Wolgerlerner, cardiologist, I acknowledge that meth at this level can be toxic, is capable of causing death. He had a large heart, but that didn't harm him. That is nothing that has the cause of death. There's Dr. Mitchell, forensic pathologist. He understands the methamphetamine level. He understands the large heart, but it's the physical restraint that causes death. Dr. Smart, another emergency room person who frankly says that, look, I've seen meth doses, double this. Not an issue. That doesn't cause no problem whatsoever. He simply died because he was restrained. Then you have an epidemiologist, Dr. Freeman, who does statistics and uses a statistical approach, saying, well, if a person uses methamphetamine, only one person in 400,000 died, therefore this could not have been that type of a dose to cause his death. We will get into his testimony on the stand, testing his theories regarding the statistical analysis and how it applies in this particular case. And then you have Dr. Veal. And Dr. Veal, another one who says that there was a variety of things that was going on at that point in time. He was tased, but that didn't affect him. He was high on meth. That certainly could affect him. He was restrained, and that probably affected him. But again, they kind of discount what it is that Dr. Clark says. Conversely, you have the defense medical experts. There's 6 of them. And their testimony, I anticipate, will be from Dr. Stankus. This is a toxic ingestion of methamphetamine that causes death. Dr. Marmoreto, hypoxia had nothing to do with this individual's death. He was high on meth. Dr. Levine died of acute meth toxicity. Dr. Fishbein, it's meth intoxication. And significantly, Dr. Reese, who said he had been using meth and he was in a meth-induced psychosis. Meth-induced psychosis. These experts not only accept Dr. Clark's opinion, they embrace his opinion. They don't try to create some other event that occurred. They accept the facts that are presented to them for purposes of considering the evidence. Now, a couple other things that we need to speak about here is that what other independent evidence is there that is suggestive to how it is that Mr. Ellis died, the encounter that he had with Officer Burbank and Officer Collins on that particular evening. I told you how short the encounter was, but 2 parts that are here is that here at the car, below the window, you're going to see this box of donuts, which was inspected, and the officer that inspected said the box was open. That's the first thing. The other is that there's a bottle of water that rolled to the side, and these are the 2 items that Mr. Ellis was walking with that night when he came into contact with Officer Burbank and Officer Collins. There's also the smearing on the window. Now the state says, well, we didn't test it. Therefore, you can't believe what it is. Take a look and use your common sense and say, okay, this guy's got a box of donuts that's open. We have smearing on his windshield, which is smearing of powdered sugar. It doesn't take a person with a heightened degree to understand this is consistent with what Officer Burbank stated was the event. That is what we have here. And so in addition to that, we have historical information regarding Mr. Ellis. We know that there was an event in 2015. 2015, 5 years before this event, he was high on methamphetamine, caused him legal difficulties, caused him to be hobbled by officers to restrain him, to stop him from acting the manner that he was acting. We have the event in 2019 where this is frighteningly similar to what occurred in 2020. He was running down the street, Pacific Avenue, naked. Officers were after him, and he's down on the ground, and the officer said, "Stay down, do not get up, stay down." Mr. Ellis gets up, he is naked, and he charges the police officer. Officer shoots him with the taser, he drops to the ground. He recovers, he gets back up, and he's charging the officers again, and they tase him. And at that point in time, in the second tasing, they were able to apprehend him. They were able to arrest him, and then he was charged with offense. To Mr. Ellis's credit, he recognized the only reason the officers didn't shoot me because they could tell I was in a meth psychosis, and that's why I'm still alive. That's why I'm still alive. And then we have the event where he is high again in 2019 in December, and then unfortunately on this period of time in 2020. Now, that is a brief, very brief overview of the evidence that I anticipate that you're going to hear from the stand. You're going to hear witnesses testify. You're going to hear a myriad of police officers that will get up here and testify about their encounter with Mr. Ellis on that evening that is completely devoid of Officer Burbank or Officer Collins be there because they were exhausted. They were absolutely they were done. They could no longer work at that point in time. Officer Collins said my wrists were so tight I couldn't do anything. The lactic acid had expelled me from being able to assist in any other fashion. Officer Burbank was the same way. He goes, I was done. I was simply done. And as all officers do, when there are other officers around, he relied on the other officers to continue to secure the scene. And not until the scene was secure did this event come to an end. Now, in jury selection, we talk about Black Lives Matter, Blue Lives Matter, racial profiling, all these other buzzwords. And for those of you that have seen the news media, this is where the facts come from. This is the information that the 12 of you that are going to decide this case will get your information for purposes of deciding this case. Nothing in the newspaper, nothing on the radio, nothing on the TV. Right here, this witness chair, and the exhibits that are presented to you will help you decide this case. You have all been selected for a variety of reasons, but the biggest one is that you can be fair and impartial to both sides. And we're going to hold you to that. Because this case is tremendously important for the state. It is tremendously important for Officer Burbank, Officer Collins, and Officer Rankine. So with that, I trust that you will keep an open mind, listen to all of the evidence, and then when we're back in front of you for closing remarks, remember to consider the evidence and the lack of evidence that the state has to produce in this case. Because when you do that, I would suggest that the only appropriate verdict that you can return is that of not guilty. Thank you. Thank you.
Okay, thank you. All right, we're at 12:05, so we're going to take our noon recess at this time. Ladies and gentlemen, do not discuss case among yourselves with anyone else. Do not permit anyone to discuss case with you or in your presence. Please be back to the jury deliberation room by 1:15. Thank you all very much.